Now we will discuss the topic of investigation, inquiry and trial as per the Criminal Procedure Code. Investigation, inquiry, trial. These are the three stages in a criminal case. Section 2, Clause H of the Criminal Procedure Code gives definition of the word investigation. Definition of investigation. Accordingly, it means and includes all the proceedings under this code for the purpose of collection of evidence. Proceedings for the purposes of collection of evidence, and it is conducted either by a police officer or by any other person who is so authorized by a magistrate in that behalf. So, investigation means and includes all the proceedings under this code, means as per this Criminal Procedure Code. For what? For the purposes of collection of evidence. Who conducts such proceedings? Either by a police officer or by any other person who is so authorized by magistrate in that behalf. So this is the definition of investigation. Then inquiry. Section 2, Clause G of the code defines the word inquiry. Accordingly, it means every inquiry other than a trial which is conducted under this code by a magistrate or a court. So, what is the inquiry? Every inquiry other than a trial, and conducted by whom? By a magistrate, that is judicial magistrate, or a court. In common parlance, the words investigation and inquiry are used as synonymous or interchangeable terms. However, the Criminal Procedure Code uses them differently with specific distinct meanings. So, as per the Criminal Procedure Code, the meaning of investigation, meaning of the words investigation and inquiry, it is distinct and different. It is not one and same thing. According to code, investigation is to be conducted always by a police officer or by any other authorized person, and it includes all the proceedings for the collection of evidence. An inquiry is never conducted by the police, although in common parlance we talk of police inquiries. So even though we generally commonly says police inquiry, but inquiry is never conducted by the police. Investigation is conducted by the police. So what is the definition of inquiry? As per the code, it means every inquiry other than a trial. So what is trial? The word trial has not been defined in this present code of 1973, Criminal Procedure Code 1973. However, under the earlier old code of 1898, the term trial was defined. So in previous code it was defined. The term trial was defined as the proceedings which is taken in a court, which court? Trial court, after the charge has been drawn. So it is a proceeding taken in a trial court, and when it is taken after the framing of formal charges by the court. Thus, a trial means the judicial process which is conducted in accordance with the law, whereby a question as to guilt or innocence of any accused person is determined. Charge means it is a formal accusation which is to be drawn up by the trial court. And after drawing such charges, trial proceeding get started. So trial means the judicial process. For what it is a conducted trial? To determine the guilt or innocence of any accused person with the help of evidence. When any police officer receives the information about commission of cognizable offence, then he immediately starts the investigation. In our previous lectures, we have seen in detail the cognizable offences and non-cognizable offences. So when any police officer receives the information about commission of cognizable offence, then he immediately starts the investigation. Information. When he receives the information, when any police officer receives the information, and if he concludes that this information is relating to cognizable offence, then he has to report. He has to report in the prescribed manner that information. And after reporting, it is generally known as FIR, that is First Information Report, FIR. Besides, when the magistrate directs the police, especially in case of non-cognizable offence, then also police conducts the investigation. So we have already seen that in case of cognizable offence, police can start investigation even without the order of any magistrate or court. But in case of non-cognizable offence, police officer cannot start such investigation without order of the court. So when the magistrate orders the police officer to conduct the investigation in the case of non-cognizable offence, then police can start the investigation. Thus, on receiving the complaint, whether in respect of cognizable or non-cognizable offence, the magistrate may not take cognizance of the offence for which there is a complaint. Instead, he may send it to the police for the investigation under section 156 subsection 3 of the code. Complaint. Complaint, it is made to the magistrate, formal complaint. Generally, it is made with respect to non-cognizable offences. Generally, complaint relates to the private wrongs. But it is not the case that complaint cannot be made with respect to cognizable offences. So, when the magistrate receives any complaint, whether it relates to cognizable or non-cognizable offence, then for the purpose of taking cognizance of such offence, he may send it, the magistrate may send it, said complaint, for the investigation to the police. And he send it, magistrate send it for the investigation under subsection 3 of section 156. So what is complaint? Complaint, generally we commonly talk about complaint to the police, but complaint is never made to the police. Complaint is always made to the court of judicial magistrate. We give information to the police about commission of offence. Information. So, to the police we give information, and to the judicial magistrate we make formal complaint. And if that information given to the police, if it relates to the cognizable offence, then it is reported by the police in the prescribed manner, then it is called as first information report. So complaint is never made to the police, it is always made to the magistrate, judicial magistrate. Definition of complaint. Section 2 clause D of the Criminal Procedure Code gives definition of a word complaint. It means any allegation. Allegation either made orally or in writing to a magistrate, to a judicial magistrate, with a view to his taking action under this code that some person, whether known or unknown, has committed an offense. So what is complaint? What is complaint? It means any allegation that some person, whether known or unknown, has committed an offense. To whom it is made? It is made to a judicial magistrate. How it is made? It may be made orally or in writing, but generally it is made in writing, in practice. Why it is made to the magistrate? With a view to his taking action under this code regarding such allegation. So, by making a complaint, we request the magistrate to take appropriate legal action as per the Criminal Procedure Code with respect to such allegation. Ordinarily, a private citizen who intends to initiate the criminal proceeding in respect of any offense has two courses that are open to him. So, any person who wishes to initiate criminal proceeding, two ways. Thus, he may give information to the police if such offense is cognizable one. So generally, in case of cognizable offense, information is to be given to the police, then it becomes FIR. This is the first way. Or he may go to the magistrate, judicial magistrate. He may go to the court of judicial magistrate and file a complaint, formal complaint, irrespective of whether such offense is cognizable or non-cognizable. So, in case of cognizable offense, he can give information about it to the police. But he can also make a complaint regarding cognizable offense to a magistrate. And in case of non-cognizable offense, he has to make a formal complaint to the judicial magistrate. Because in case of non-cognizable offense, until the police gets order from the magistrate, they cannot interfere into such non-cognizable case. But if such complaint discloses the cognizable offense, the magistrate can send it under section 156 subsection 3 to the police for its investigation. So when complaint relates to cognizable offense, then police, before taking its cognizance, can send it for investigation to the police as per the provisions of subsection 3 of section 156. Thus, a complaint in a criminal case is that what a plaint is there in a civil case. A complaint is one of the modes by which a magistrate can take cognizance of an offense. Generally, in cases of non-cognizable offense, a person who is aggrieved by such offense makes the complaint to a magistrate. Person who is aggrieved means because of the commission of offense, who has suffered some damage or injury, he can make a complaint to a magistrate. So it is relating to complaint. Then, after completion of the investigation by the police and on the basis of material, that is evidence, which have been collected by the police, if the police officer forms the opinion that now the case is such where the accused person can be placed before the magistrate for the purpose of trial, then such police officer files the charge sheet under section 173 of the Criminal Procedure Code. So after completion of the investigation, police officer files the charge sheet in the court of judicial magistrate. Here the charge sheet is also known in practice as a challan, which is the report of investigation by the police. So report of investigation means a charge sheet after completion of evidence. After submission of the investigation report, that is charge sheet, by police, the next stage is about the inquiry. So at this moment the stage of investigation is completed after filing of the charge sheet. Now the second important stage it get commenced, that is inquiry. On the basis of the police report, especially in cognizable case, the magistrate takes the cognizance of offence. So on the basis of police report, magistrate takes the cognizance of offence for the purposes of trial. Similarly, on the basis of complaint, especially in non-cognizable case, such cognizance of offence can be taken by a magistrate. So in case of non-cognizable offence, on the basis of complaint, magistrate may take cognizance of an offence. However, for the purposes of taking cognizance of offence, some preliminary inquiry needs to be conducted by the magistrate. So here the next stage of inquiry comes into picture. Inquiry for what? For the purpose of taking cognizance of offence. As per the section 159 of the code, Criminal Procedure Code, upon receiving the police report, even in any non-cognizable case, the magistrate may proceed to hold a preliminary inquiry. So even with respect to non-cognizable case, magistrate may direct the police officer to conduct the investigation. And after receiving the report of investigation, magistrate may proceed to hold a preliminary inquiry. Similarly, as per the section 202 of the Criminal Procedure Code, where a complaint is made to a magistrate, he is empowered to postpone the issue of process which is required for compelling the attendance of accused person, and instead such magistrate may firstly undertake an inquiry into the case. So under the section 202 of the Criminal Procedure Code, before issuing the process, magistrate may firstly undertake an inquiry into the case. Process, what is process? Process, why it is required? It is required for compelling the attendance of accused person. So where a complaint is made to a magistrate, so complainant insists the court of magistrate, please issue the process for compelling the attendance of accused person in the court. Process generally includes summons or warrant of arrest. So even though complainant insists before the court to issue summons or warrant of arrest for compelling the attendance of accused person in the court, then also court is empowered to postpone the issue of process, court of judicial magistrate. and magistrate may firstly undertake an inquiry into the case. Why such inquiry is needed? Here such inquiry by a magistrate is necessary for determining whether or not there is a sufficient ground for proceeding further for the purposes of trial. So, inquiry for determining whether or not there is a sufficient ground for proceeding further for the purposes of a trial. Besides, such inquiry is also necessary to ascertain at preliminary level the truth or falsehood of the complaint. So it is a preliminary inquiry. Magistrate has to determine whether the matter is such which can be tried. So whether there is a sufficient ground for further proceeding for the purposes of trial. To determine this, inquiry is to be conducted. Upon such inquiry by the magistrate, if he thinks that there is a prima facie case for which trial proceeding can be conducted, then there comes the next stage of the case. When magistrate is of the opinion that there is a prima facie case for which trial proceeding can be conducted, formation of such opinion or coming to such a conclusion, it means taking cognizance of an offence. So taking cognizance of offence means magistrate thinks it that there is a case, there is a sufficient ground now for proceeding further for the purposes of trial. So this task means it is known as taking cognizance of an offence. So when magistrate comes to such a conclusion that there is a prima facie case for which trial proceeding can be conducted, then there comes the next stage of the case. So stage of inquiry ends here, and the third stage, that is stage of trial, now begins. Thus, when such offence of which the magistrate has taken cognizance can be tried by himself, then he frames the formal charges against the accused person. So, firstly the magistrate take cognizance of offence. He take cognizance means he comes to a conclusion that there is now sufficient ground for further proceeding for purposes of trial. Then second thing he has to determine, judicial magistrate, whether such offence is triable by him or whether it is exclusively triable by the court of session. And if he comes to a conclusion that that particular offence is triable by him, then he frames formal charges. Without framing formal charges, trial proceeding cannot get started. Before framing the formal charges, magistrate can issue the process, that is either summons or warrant of arrest. The magistrate can issue the process against such accused, as the case may be, for compelling the attendance of such accused for the purposes of trial proceeding. Unless the accused is before the court, trial proceeding cannot be started. And for the purpose of compelling the attendance of accused person, either summons may be issued or, if required, warrant of arrest may be issued. So when the magistrate issues the process against the accused person, it indirectly means that magistrate has taken the cognizance of offence. And if suppose the magistrate comes to a conclusion that the offence is such which is exclusively triable by the session court, then in that case he transferred that matter for the purpose of trial to the court of session. It is known as commitment of the case. So If such offence is such which can be exclusively tried by a session court, then such magistrate, judicial magistrate, commits the case to such session court for the trial. Thus, a trial proceeding relates to an offence through which the court is empowered to convict or acquit the accused person as the case may be. What could be the outcome of the trial proceeding? Either conviction of the accused person or acquittal of the accused person. Conviction means after the trial, with the help of evidence, if guilt is established and if the accused person found guilty, then trial court passes the order of conviction. And if the trial court comes to a conclusion that there is no evidence which shows that accused person has committed any offence, then trial court passes the order of acquittal of the accused person. On the following points, there is a difference between the inquiry and trial. With respect to an offence, the inquiry is undertaken for taking cognizance of offence. So what is the purpose of inquiry? For taking cognizance of offence. That means determining whether there is a sufficient ground for proceeding further for the purposes of trial. Determining whether there is a prima facie case or not. Whereas the trial is conducted for deciding the guilt or innocence of the accused person. So trial proceeding means a proceeding where evidence is to be laid, prosecution lead their evidence, then accused person through his defense counsel leads the evidence before the court. So what is the purpose of trial proceeding? To determine the guilt or innocence of the accused person. Thus, on considering the time factor, it can be said that the moment where the inquiry comes to an end, the trial begins. So as I said earlier, when the stage of inquiry comes to an end, the trial proceedings begins. When the magistrate has taken cognizance of the offence. In relation to an offence, an inquiry may result into the discharge of an accused person where the magistrate is of the opinion that there is not any sufficient ground for proceeding further for the purposes of trial. So after making a preliminary inquiry, if the magistrate comes to a conclusion that there is a sufficient ground for proceeding further for the purpose of trial, then it means that he has taken the cognizance of the offence. But on the contrary, when he comes to a conclusion that there is not any sufficient ground for proceeding further for the purpose of trial, then the magistrate will pass the order of discharge of an accused person. Order of discharge. What is the opposite word of discharge? Charge. Means if the accused person is not discharged, then the magistrate court frames the formal charge. Charge means it is a formal accusation regarding commission of an offence. So if no charge, then discharge. If no discharge, then charge. And if the proceeding is initiated upon a complaint, then such inquiry may result into the dismissal of complaint, where the magistrate forms the opinion that there is no any prima facie case, and there is no strength in such complaint as it appears to be not true. So after making preliminary inquiry, in case of non-cognizable offence, when any aggrieved person makes a complaint before the court of judicial magistrate, then for the purposes of preliminary inquiry, magistrate conduct primary examination of the complainant and his principal witnesses, and on that basis, if the magistrate comes to a conclusion that complaint appears to be false complaint, there is no strength in such complaint, there is no any prima facie case, then in that case the magistrate can pass the order of dismissal of complaint when the proceeding is initiated on the basis of complaint. So in short, we have seen now the three stages, important stages in the criminal prosecution of any case. That is, first investigation, which is conducted by the police for the purpose of collection of evidence. Then comes the stage of inquiry, which is conducted by the judicial magistrate for the purpose of taking cognizance of offence. And the third stage is trial, when the magistrate takes cognizance of the offence. Trial is conducted for determination of the guilt or innocence of the accused person, and it always results into either conviction order or acquittal order. So we will consider some another topic in our next part of the video lecture. Thank you very much.